A little bit of applause. All right, we are, for the people who are watching on Zoom, we are getting started here. This is our welcome to our current and emerging issues in technology, IP, entertainment, and media law, our annual sort of roundup of what's happened this year in these areas of law that are rapidly changing and ever interesting to talk about. So I have three of my colleagues up here with me to talk about these issues. Professor Christopher Yu is the Imasogi Professor in Law and Technology and the Director of the CTIC, along with myself, and is going to talk about issues related. Well, he's an expert in many areas, but competition law, privacy, intellectual property, communications, telecommunications, and has been doing work in AI as well. Gerald Adams is a Sharswood Fellow here at the law school and a graduate of this fine institution, and is currently teaching a seminar in space law, and is an expert in not only that area but in areas of communications, antitrust, regulation, and associated sorts of areas. And then last but certainly not least is Jennifer Rothman, Nicholas Galico, Professor of Law, who is an expert, as many of you know, in rights of publicity, trademarks, intellectual property, and a variety of other areas related to that as well. So welcome to everybody. And so the way that this is going to go is I'm going to start by sort of asking each of my colleagues to talk a little bit about what's going on or what has gone on over the last several months in their areas of particular interest, and then we will sort of start a general conversation about things that are going on. Those of you who are on the Zoom can put questions in the chat and we will get to them. So a couple of housekeeping items before we go any further. This session is being recorded, just be aware of that. If you want CLE credit and you are online, we will be giving out 3 passwords during the event. Please make a note of them for your CLE form. The first password is neutrality. And then there will be some time for Q&A at the end. All right, with nothing more?
Neutrality.
Neutrality.
Do the people here need it?
Yeah,
They do.
they do.
Yeah.
Yeah, that's a new,
Just so I know.
a new.
All right.
All right.
Yes. All right. So that's the first password, neutrality. And with that, Professor Yu.
Well, thank you. Appropriate of the word neutrality, it's an issue usually preceded these days by the word net, and it's a fight that's been going on since 2004, really, in full bloom. I've been predicting its death since 2007. It goes to show how much you should value my predictions. It's not worked out that way. And it's interesting, I
Your
wrote...
predictions may be right, just not time.
Yeah. But they always say that we, overestimate what we can do in 5 years and underestimate what we can do in 10. But I wrote the response to Tim Wu's article in which he coined it, and we've been fighting about it ever since, and it's been entertaining. So I had a role in getting the fight started. I won't take any blame for how long it's gone on, but on I think the first week in January, when no one was paying attention, the Sixth Circuit dropped an opinion that very well may represent mostly the end of the net neutrality fight. So up until now, it's depended on the construction of the statute, which was done under Chevron, in which courts defer to any reasonable interpretation that the agency makes. There's a key issue, which I won't bore you with. Courts had interpreted, the FCC interpreted it one way, the court said that's reasonable, Supreme Court said that's reasonable, interpreted the other way, Court of Appeals said, well, that's reasonable, and within the world of Chevron, this is an example of the kind of flip-flopping that could happen that led to the decision in Loper Bright by the Supreme Court to overrule the deferential approach to statutory interpretation. The Sixth Circuit had a decision which initially at the stay level, they stayed it under what we call the major questions doctrine that says there are certain issues that are big enough, should only be decided by Congress, not by agencies. When it went to full merits decision, they relied on straight statutory interpretation without needing to reach the major questions doctrine. And they said that, in fact, net neutrality is outside the agency's authority to impose. Now, what does this mean? For the purposes of the 2024 order done by Biden, that is now a nullity. We now revert back to the 2018 order done under Trump. Is this the end of net neutrality? Not necessarily. A new administration could pass a new rule and get it appealed. If it goes back to the Sixth Circuit, they'll probably be bound. But as you know, circuit authority is only persuasive authority in other circuits. So therefore, if it went to the DC Circuit or the Ninth Circuit or any other circuit, they would evaluate it on their own merits, giving due weight to what the Sixth Circuit said, but not bound by it. So it's possible we'd see another round. But what we will see is, because it's no longer about deference, is no longer see this revolving door based on presidential administrations. It's going to get resolved in a more conventional legal manner than we've seen up until now. And so the other thing that's kind of interesting, though, is it's sort of, the steam has kind of gone out of the fight. We've gone back and forth so many times. All the actors kind of say, well, we can live with it either way, which makes you kind of wonder why people fight over it so much. I will say, a lot of politicians raise money on it. It's an issue that attracts a certain amount of political attention. Whether it's actually justified in terms of mind space that we've given it, a lot of people have, maybe once upon a time, but now increasingly the answer is coming no. But here we are. Item 2. So other things that are going on. There was, in January, that wasn't the only big thing. There was another major First Amendment case, which was TikTok, which is something to all the people your age is probably a lot more interesting than is of key importance to people like me. I don't think I've ever really watched a TikTok video. So I mean, I know my students are looking. Yeah, I know. So the bottom line was the DC Circuit, basically the Congress passed a statute declaring TikTok to be illegal because of concerns about infiltration of security risks involved in TikTok. There's a statutory provision allowing the ban to be stayed if they're likely to be acquired by a US company. It was upheld on the constitutional level by the DC Circuit, went to the Supreme Court, was argued in a matter of days, and if anyone who would know, it's extraordinary for that to happen. The only example I know of that comes to mind is the Pentagon Papers case. It only happens a handful of times, and they issued a decision in a week. And it's extraordinary that they basically agreed with the DC Circuit that it was constitutional. And that's extraordinary for two reasons. One, they did it under strict scrutiny. And the idea that something passed strict scrutiny is extremely unusual. And it may be the only example that comes to mind readily. Second is that why the Supreme Court bothered just to put its imprimatur on the same decision the DC Circuit already made is unusual. I mean, they don't usually feel the need to say, oh, we agree. If it was fine, they would normally just let it go. And so I think it deals with the extraordinary politics around this. As you probably know, Trump said he would get this settled very quickly. Here we are, 3 months into the administration. He stated several times, theoretically, the only legal basis is if there's an imminent buyer. It's not clear there's an imminent buyer. There are some companies that haven't had consumer-facing businesses like Oracle who are thinking about buying it. I actually think it'd be a really good thing. And creating another company with a consumer-facing business from a pure competition law standpoint in there would probably be a good thing. It's interesting. Just very briefly, there's one unresolved First Amendment case called Free Speech Coalition versus Paxton. It's a statute from Texas requiring platforms to do age verification, social media platforms to do age verification. And the big question is, how burdensome is this? And are you going to to borrow the line from Butler versus Michigan, are you going to reduce the content available to adults to what's appropriate to children? And that is always the benchmark. Clearly, you can do some sort of kid-child verification up to a point, but if it's too burdensome, you probably can't. There was a 1997 decision called Reno versus ACLU, where they struck down some child verification provisions. That's probably going to get some weight. But unlike a lot of the First Amendment cases, the oral arguments happened, and the would-be pundits who watched it are split on reading the court about how they're going to come out. And as you know, trying to predict outcomes based on oral argument is a risky business at best, but we don't know exactly how that's going to come out. Closing with two things. In this, there's another Supreme Court case where there's a non-delegation challenge to the universal service system. It's an insider baseball thing that I bored my students with earlier in the month, and that I won't go into any length here. The second thing that's out there is the current chair of the FCC is using broadcast regulation, which most of us, myself, one of the first articles I wrote was saying this is all obsolete, to go after NBC, CBS. NBC, they're criticized them actually with some appropriateness for putting Kamala Harris on Saturday Night Live the night before the election without offering equal time to the other candidate. That would be unconstitutional under any other media except for broadcasting, but for our rules under Supreme Court precedent, it's constitutional with respect to broadcasting for reasons that people think are suspect. But in addition, the thing that came across the wire yesterday is Brendan Carr is complaining that Comcast, who owns NBC, is biased in its reporting about the immigration deportations. And the idea that you would do that is extraordinary. I mean, this is
He's the chair of the
the chair of the
FCC.
Federal Communications Commission with enforcement authority of these things. And this is a very, very unusual move that's almost unthinkable. And the other things I'm tracking, the other thing I'd say is I'm also tracking the way Europe has been running around trying to do what they call the Brussels effect, which is they passed their privacy regulation. They now have their Digital Markets Act, which is their big tech competition style regulation. They have an AI regulation and a bunch of others, and they're trying to convince the rest of the world to follow their lead. Historically, the US has set the pace. The EU is coming on. My read, having traveled a lot of places in the world, is one, most countries are not going to act to follow the lead. It's unlikely. And second is, there's a sea change right now. Instead of worrying about other problems the Trump administration is focusing on structural deregulation. Europe followed the Draghi report, is trying to figure out how to enable innovation. And the UK just fired about a month ago its chief competition regulator because they thought it was impeding innovation too much. And so there's a very real change in the discourse right now towards enabling innovation instead of just focusing on the harms that it can create.
Interesting. And then you said you were going to talk a little bit about the AI.
Oh, AI, there's three big issues. I'll let Jen talk about one of them, but one of the big issues that's floating around is training data. Can you train AI on copyrighted works? And the answer is there's lots of fights over this. There's some other countries, Japan has made this per se legal by statute to try to encourage it to be a place where people would train things. And the assumption has been, the fight has been all along that this is going to be fair use. That in fact, you're not using it for the content, it's going to be fairly modest in terms of impact, and looking at cases like Google Books, maybe to some extent Oracle, and other cases that it's likely to be working out that way. Our own Stefanos Bibas, adjunct professor, former full member, and now Third Circuit judge, when sitting by designation in the District of Delaware, recently issued a decision in Ross Intelligence versus Thomson Reuters that the use of copyrighted works in training data was not fair use. And this is a big deal. I mean, this is the first major decision. It's a district court decision. We don't know what its influence is going to be, but it's really unusual. All of us who are lawyers here understand this. It's a question of head notes in West's case reporters. And he apparently read all 20,000 head notes in issue verbatim, because he's very, very meticulous and very conscientious, and actually compared them and really focused on the idea that the product being done by AI was a direct replacement competing with the existing content. So this isn't some sequel or some fan fiction or something. It was really competing directly with it in ways that are very narrow, and on that basis he came to the conclusion he did. I would say reading things like Google Books and Aribasoft in the Ninth Circuit and to some extent Oracle, he's citing cases that are still good law, but the general interpretation of what fair use has been broader than what we saw in Harper and Row and all the older cases. And so it'll be interesting to see. He may be following straight Third Circuit law, but other circuits have broadened the notion that if things are more functional, they are more inclined to be transformative in that ways in the balance in ways that he did not put a lot of weight on. So that's one shot across the bow. I think Professor Rothman's going to talk about authorship, and the other one is regurgitation, which is if the work comes up with the underlying work, is that infringement? And the famous thing that we're floating around with right now, there's a computer science study that if you tell AI to repeat the word poem over and over again, it will start regurgitating personal information on which it was trained. And what you realize is that all AI is correlation engines that are drawing back to its training data. And if you give it a prompt that has almost no context and do it over and over again, it will regurgitate the training data. And that is just if it has nothing else to go on, it'll latch onto it. We also have these very famous examples. If you asked AI, how do you keep toppings from falling off your pizza? They said use Elmer's glue. That's because someone as a joke answer in Reddit once gave that as an answer, but when you look at the whole body on which it was trained, that's the only answer it found, so it gave it as an answer. There's these very odd things that can happen, but the answer is there's no question that AI can regurgitate the data on which it was trained, some of which could include copyrighted works. We have all these lawsuits in different forms that they're fighting about now with the New York Times and others who are struggling with this.
Excellent. All right. Thanks very much. And we'll go to Gerald. Great. What's going on in your area?
Yeah, big tech on trial, right? Starting last summer and now permeating up through today and will continue well after today. I think we start with the one that's the most fresh, which is the Google Ad Tech case. The opinion came out, I believe, this morning. 115 pages, so not quite as weighty as the other Google case that we'll also talk about. So if I'm looking at my notes, it's because I was trying to, power skim through it prior to this discussion. But I'm sure news outlets will provide equally as applicable, if not better, synopsis than I will. So what the ad tech ecosystem is doing, right? It's everything working on the back end to provide those really annoying pop-up display and text ads on everything you browse or any website you go to, right? Google was the mastermind behind all of it. And the way that it had been structured, right? Google had initially managed what was known as ad choice. That was what we're calling the buy side or demand side of this market-making system that they had. It originally started so that advertisers could have placements on Google's own search results. It then turned into the broader web ecosystem. They also would then go on to purchase what's known as DoubleClick. That was the publisher side. So essentially, you are a website publisher or some other affiliated entity that displays things on the web. You want somebody to manage and configure where advertisements are going to show up, what kind of advertisements are going to show up, and who's going to, do all the finagling to make sure the advertisements are there. Google would eventually acquire DoubleClick, so now they not only own buy side, they own publisher or sell side. With DoubleClick, they also acquired the ad exchange. So on the back end, Google is managing this entire market ecosystem. The Department of Justice, along with, I believe, 8 states attorneys general, filed suit in 2023, essentially saying, this is a monopoly, this is engaging in monopolization. The formal charge was violation under Section 2 of the Sherman Act. Looking at a myriad of behaviors. So the big highlights that show up in the opinion, right? The ad exchange demanded that if you were on the demand side, if you were using ad choice, you had to go through Google's ad exchange. The real-time bidding that was occurring on the publisher's side also had to go through DoubleClick to the ad exchange. If you wanted to use an outside ecosystem, you had to use a completely different array of products. You couldn't pick and choose which parts of Google's ecosystem you wanted to use. So what comes out of this is, judge ultimately finds, yes, Google has a monopoly, Google has engaged in monopolization, it's violated Section 2. What are the interesting components, at least from what I could parse in the opinion thus far, right? The market that is defined in the opinion is very odd, in that it defines 3 separate markets. That buy side, that sell side, and the exchange in between are all distinct markets. It seems intuitive and maybe clear, but we had a Supreme Court case, right? When was Amex? 2016?
Yeah, that sounds right.
Yeah,
2018?
Maybe 2018. Anyway, we had a Supreme Court case involving American Express credit card company also providing transaction services, right? It's a market maker. There's 2 sides of a market. They're bringing folks together. They're providing what's essentially a matchmaking service. Under Amex, the Supreme Court said, no, you need to look at and include both sides of said market when you define the market. Right? If this is a 2-sided platform, the market definition is to include both sides. This opinion does not do that. Right? It goes out of its way to explain why it's not doing that, why it thinks that this ecosystem is distinct from the credit card service, whether that will survive the inevitable appeal that's going to come with it is to be seen. It also is going to be very complicated because the judge only found market power in 2 of those 3 markets that were defined. So, quite strange. That complements the other Google decision, right? Google search opinion came out over the summer, essentially saying that Google was a monopoly in providing general search services. Also, somewhat strange market definition being provided there in that Judge Mehta DC District Court went out of his way to suggest that any sort of vertical search provider is not included in that market definition. So think Amazon services, think Booking.com, Hotels.com, not a general search service. Also found in making that market definition, market power of upwards of 90% of the market. Okay. Why do we care about Google search still, right? Should be old news. Well, starting Monday, there will be a 3-week hearing at the DC District Court to determine what are the remedies going to be. So the court had bifurcated this proceeding, essentially saying, we're gonna figure out whether there's a monopoly here in the event that we do, and they did. Now we look at what's the remedy supposed to be. How are we going to reestablish competition in this market? It seems by and large there's been 3 remedies, at least largely proposed. So the Googles of the world have essentially said, well, you should do what you usually do in this circumstance, just enjoin what were default contracts. So the monopolization conduct in Google search was Google had essentially established default contracts with a lot of providers. Think Mozilla for general search, think Apple's ecosystem, right? Samsung, they essentially were the default browser when you hold up those pieces of hardware, your phone, your
Default search
computer.
engine.
Okay.
Default browser.
Yes, the default browser, correct.
Search engine, is it?
Default search engine on the browser.
On the browser,
Thank you.
yeah.
On the Mozilla browser. Good. Yes, default search engine. So Google's claim was essentially, well, just enjoin these default contracts. We will no longer have these agreements with the Apples and the Samsungs and the Mozillas of the world. We'll go on our merry way. The Department of Justice's argument has essentially been, well, it's too little too late. That remedy is not going to do anything. We need something more forceful. The something more forceful that the Department of Justice very clearly wants is they want a structural breakup. And in particular, they want the Chrome browser to be the breakup. We are often very hesitant to do breakups. At least we have been in the past. Who knows? Maybe we're in a new antitrust paradigm now. It's also not clear whether a breakup provides the competition or the services that are beneficial to consumers. And we can talk about that more if we'd like. But I think the third option on the table, and the option that's been proposed by a lot of scholars, including a professor in this law school who's not with us today, but knows quite a bit about antitrust, is that there should be some sort of mandated data sharing or interoperability requirement. I have opinions on that as well. I'll hold my commentary on that, but that you should at least be aware those are kind of the 3 major remedies that are being proposed. And then finally, the last one that I'll mention is trial is currently ongoing with FTC v. Facebook, essentially looking a decade later back at Facebook's acquisitions of both WhatsApp and Instagram, and suggesting the FTC's argument has been, these acquisitions were predatory to bring in potential competitors that were putting Facebook's market share both at risk as well as maybe being viable candidates to supplanting them in certain market segments. Rather than engage in competition on the merits, Facebook just decided to acquire them. Keep in mind, right, when WhatsApp was acquired, it had 50 employees. It also had no monetization structure or business model. When Instagram was acquired, it had 13 employees. So what Facebook is essentially going to argue, or Meta now in this case, is that no, the success of these services is because of us, not in spite of us. Okay. What else did I want to mention? So sticking on the topic of platforms, there's been a myriad of state laws as well as a few bills going through Congress essentially saying that we need to provide some sort of regulation on these personalized recommendation systems. What is the fancy way of saying curation algorithms that all of these social media platforms are using? The foil in most cases is Facebook or TikTok. Professor, you already mentioned there's First Amendment implications here, specifically with Paxton and challenging the Texas law. The Texas law is not the only one. There's been many states have now at least attempted to enact legislation. Many of those have been challenged on First Amendment grounds. Those are not the only grounds that those bills are being challenged on, or enacted laws in some cases. Many of them have a veneer of public health concerns, particularly for minors and for children, with all of the restraints, again, similar to what Professor you mentioned, but also on top of age verification, some of them have outright prohibitions for minors. They have mandated requirements that the data be able to be accessed by the parents without child's consent. They have restrictions on when and how it can be used. I think probably the most egregious one I've seen is from my home state of Utah, which on top of all of those things, it has every one of them, includes a private right of action that presumes, so private right of action in that child says they have some sort of mental health harm, right, or having suicidal thoughts. They believe that said platform or service is the trigger for those harms. A parent can then, on behalf of the child, essentially sue the platform, saying, you know, we think TikTok, for example, is harmful to Billy or Sally for X, Y, and Z reasons, and we have a doctor's note to prove it. Now, what's harmful or what's scary about this law? Well, it presumes causality. It essentially says, well, if you come with a doctor's note, we will presume that TikTok is the cause of said harm. Now, TikTok has to rebut that presumption, but how do you rebut that sort of presumption? It's quite difficult. In my personal opinion, that is quite extreme. Even in a strict liability regime, you have to prove causality. Just presuming it on the front end is quite scary. I think I'll end there with the platforms. Again, there's a lot of crossover between what I do and what Professor Yu does. So the only other things I will mention about the FCC in particular, getting back to space law to some degree, is right now there is a lot of pressure from Congress to reevaluate an FCC decision that occurred last year. That decision involved Starlink, the SpaceX satellite broadband service, applying and initially receiving almost $1 billion, it's like $880 million in grants through what's known as the Rural Digital Opportunity Fund. It's essentially a fund that's set up by the FCC. They do an auction and say, we want you to provide service to rural America. How much will it cost? If you're the lowest bidder, putting it simply, you win. Now we give you the money to go deploy that service. Starlink had won a bunch of these contracts. The FCC then came back after the fact and said, well, we're not sure you can meet the quality and speed thresholds that we'd like to see for rural America, so we're actually going to revoke those grants. The reason why this is so much strange is for every other operator that was in a satellite service, they gave everyone the benefit of the doubt and said, here's a 3-year period to prove to us that you can deploy the service. In the event that you can't, right, then we'll talk about taking the money back. They did not give that opportunity to SpaceX. They essentially looked at it ex ante and said, we're not sure right now that you can provide this service 3 years in the future, so we're just going to take the money back. Multiple senators are very upset about that. However, I will note that Chairman Carr mentioned today they do not anticipate reversing that decision. And then complementing that, there is also NTIA, right? Separate entity, the executive branch that's also providing a measure for connecting rural America. Came through the infrastructure bill, about $42 billion. They were supposed to disseminate funds to the states, and the states would then make a determination on how they were going to best serve their rural communities. There was a very strong presumption initially from the Infrastructure Act that these funds would be used for fiber. It has thus far been, I don't want to be too extreme, but I would say spectacular failure in terms of its deployment. And so now there is a strong push, maybe it's the winds of this administration on top of it, that these funds should now be reevaluated and potentially redisseminated to satellite providers like Starlink rather than kind of this expectation that they will go to fiber services.
Excellent, great, thank you. All right, Professor Rao.
All right, well, I have sort of a grab bag of things, starting with personality rights, going to trademarks, then to copyright, and maybe somehow circling back to personality rights as it intersects with copyright law, with a dash maybe of other First Amendment at the end. All right, so I want to start with proposed legislation, which I think now is in its third public draft and was reintroduced in its revised form last week, called the No Fakes Act, which may not be on your radar, but should be. I have to read you the acronym, what the acronym stands for, because I can't memorize it. No Fake stands for Nurture Originals, Foster Art, and Keep Entertainment Safe Act of 2025. Previously the Act of 2024. A lot is packed in there. Originally, this was styled to address concerns over generative AI. The initial public articulation in the one-pagers suggested that this would address three major things. One was particularly focused on recording artists and the use of generative AI to create sort of voice clones of them and then put out songs. You might be familiar with the fake Drake, which sounded like Drake was singing, but it wasn't him, and with featured vocals by The Weeknd in a song called Card on My Sleeve. And so this fake Drake really drove the entire legislation, but that was like one bucket of what Congress said this proposed bill was about. Then there were two others. The second was articulated concern out of deception of the public. And this could be very concerning from a political standpoint in elections, that someone might think there's a real action of a real human being, perhaps a politician doing something, say being, dropped down drunk on the floor of Congress, when in fact they were not. It was completely generated by AI. There were fake calls by Biden. So this was a second supposed thing that this was going to address. And the third was concerns over ordinary people having generative AI versions of them, whether in voices, some of which have been duping people in phone calls, others of which have been more pornographic in nature. There's a prominent example of some New Jersey teens whose male classmates thought it would be funny to take real images of them and turn them into pornographic images of their classmates. Using generative AI technology. So that's the purported objectives. In reality, the draft bill is very much drafted with the interests of record labels in mind. It has ballooned now.
We're all shocked by that.
Shocked. The new iteration has ballooned to 39 pages. Which should evoke memories of various additions to the Copyright Act that are bloated and difficult to understand, have numerous cross-references, and are not very accessible to the public who are trying to comply with various laws. So this very long bill was announced with a fanfare last week. In part because YouTube and Google signed on to it, which is why it's 39 pages. I won't quantify the number of pages, but the vast majority are about why Google and YouTube will not be liable under any circumstances for any uses of digital replicas on their platforms, or under very, very rare circumstances. That will never apply. So that's one reason it's very long. The other is that it very much protects record labels from any use of its recording artists, digital replicas, whether uses of their voice or uses of their visual likenesses. It provides a number of other features. So I highlight, and then there were a number of carve-outs that were added for the motion picture industry. to make sure that movies and TV shows were not hampered in their ability to use technology and digital replicas. With greater specificity, this should apply to everyone. It is styled, even in the current one-pager, as being about protecting individuals in particular, and the uses of our identities, and particularly our digital replicas. The law prohibits two things. One, and this is a long list of things in number one, the public display, distribution, transmission, or communication or otherwise making available to the public a digital replica without authorization by the applicable rights holder. Notice that we switched from individuals to rights holders there, a little trick. And then the second thing is that could produce liability is distributing, importing, transmitting, or otherwise making available to the public a product or service that's primarily designed to produce digital replicas of individuals without authorization. The scope of that is a little bit unclear. In prior iterations, almost anyone who designed software that could create digital replicas could potentially be liable. Now it's much narrower, so it has to be something that doesn't have substantial non-infringing uses. So it seems like if you allow people to make sort of digital replicas of themselves, that would mean you wouldn't be liable, and obviously any technology that allows you to make digital replicas of other people would allow you to make one of yourself. So it's not clear exactly when that would apply unless someone was actively promoting or making it really easy to use other people's unauthorized identities in creating digital replicas. There are a number of challenges to the law as written. I will highlight 4 of them. The first is that, as I mentioned, this is styled to be helping individuals, so particularly think about recording artists, think about student athletes, think about professional athletes, actors, performers, and hopefully all of us in this room. The problem is that in this version, it allows licensing of these rights for 10 years. So a few things about that. First of all, even if you thought 10 years, hey, that's not so bad for somebody else to control my voice and likeness and get to do whatever they want with it for 10 years, because then the 10 years will end. But anything made during those 10 years can be used forever by the person who made it, the licensee, or anyone they subsequently licensed to. Second, if any of those things are perhaps copyrightable, which may well be the case, then the copyright holder, this 10-year licensee or any of their subsequent licensees, would be able to make derivative works from it. So this 10-year limit is not very meaningful. And you can also imagine that on day one of the license, someone could make a pornographic digital replica of the licensee, and it will be there forever. So to address some of these concerns, the language that I will take some credit for, but which I'm not fully satisfied with, is that the license needs to be in writing and there's the language, reasonably specific about the uses. But the problem is, what does reasonably specific mean? So does that mean for use in any audiovisual works by the licensee? That would not be a limit at all, but I suppose it's specific in one sense. Could it be any Coca-Cola products? Well, that could be okay, but what if Coca-Cola decides to advertise in explicit pornographic context because that's a growth market for sodas, right? But it was reasonably specific as to soda. Or what if various licensees decide to use a person's digital replica to endorse particular political candidates, but they got this general license to be able to, again, use the person's identity. In the context of recording, the recording industry, you can imagine that every record label will now be seeking to get these 10-year licenses as part of the initial recording contract, and that will allow the record label to use the person's digital replica in the context of selling sound recordings. That's reasonably specific, but also would essentially replace the work and job of recording artists in contravention of the stated purpose of the law. So I welcome suggestions of how to not eliminate this licensing provision, but make it so that it actually could express a more specific use. Now, of course, the concern for the record labels is they actually would love to be able to, I think, replicate people in various sound recordings. But also for the movie industry, concerns, if you use a digital replica with authorization, for example, in a movie or a series of movies, you might want to change the script in some ways. You're editing, you do it differently, it will change visual effects. You don't want to have to go back to the actor every time you make one of those changes. So it's actually a drafting challenge. But I'm hopeful that in future iterations, maybe we can get something, should this pass, that would be more limiting and protect ordinary people. There's some carve-outs, so there is this in writing thing, but it's probably not sufficiently protective. In New York and California, there were recently labor laws passed to address digital replicas that require legal representation, which also may not be adequate protection if you have no bargaining power, but that's a step up from, I think, just it being in writing, because you can imagine going to an online service, whether it's Instagram or TikTok, and doing a click-through license that gives them the option to use your digital replica for 10 years that's reasonably specific if you had read the click-through, which you would not. And it would say something like, for uses of your digital replica on Instagram. And that would be reasonably specific. So I think these are some significant lack of protection. One of the main proponents, other than the record labels and supporters of this bill, is the Screen Actors Guild. They're not as worried about these things, although they don't oppose some of the more limited things I've advocated for. They're not as worried about it because they say that there's a carve out for collective bargaining agreements. So they're like, okay, someone might, have this bad license, but it's okay because any signatory that we work with for these collective bargaining agreements will have to comply with all the protections we've negotiated for digital replicas. Some problems with that are before someone joins the Screen Actors Guild, they may have already signed away rights to their digital replicas in significant ways and then not be able to get them back or be subject to the collective bargaining protections. There are also other people who make movies and audiovisual works who are not signatories to the collective bargaining agreements, so would not be governed by that. And obviously, collective bargaining does very little to protect recording artists or student athletes who aren't represented by players' associations. There are some protections that were put in place for minors, which are more protective for minors. These licenses expire at the time of 18, which is great, and they're limited to 5 years, except that managers and agents who are particularly reaching out to student athletes under 18 right now as name, image, likeness rights become more lucrative and endorsements are allowed, may sign agreements with managers or agents. And going back to this in writing piece of the language, it says it can be signed by the individual or by any authorized representative. So if a minor or a grown-up signs with an authorized representative, the authorized representative could then sign a license. So even as to minors, it's a little worrisome. If a parent, for example, has the kid sign with a manager or agent as a minor, then even when they're 18, that manager or agent can be their authorized representative and sign some of these digital replica licensing. Happy to talk more about this. I've already probably talked more about it, but in short, I think it's grossly underprotective as currently drafted of both ordinary people and performers and recording artists in ways that contravene the intent or the stated intent. Not to mention would allow for public deception, because if people don't actually have control over their digital replicas for 10 years and beyond, we will not be able to distinguish authentic appearances and performances from ones that are purely created and without any knowledge or authorization of the individual depicted. Second thing to highlight here is this creates a federal postmortem right, which hasn't previously existed in digital replicas, meaning digital replicas for dead people. This will create a massive amount of wealth in companies that manage and will own dead people's digital replicas. There's no limit on who can own these, so it can be transferred to any corporations unrelated to the individuals. And In its initial incarnation, it applies to everyone, which is all dead people, which is potentially a good thing in terms of equity and without regard to commercialization. But ordinary people only get 10 years of postmortem protection, while those who are commercialized after their death, or they say a public use, which may not require commercialization, and who register with the Copyright Office, their dead person who they're managing, that can last up to 70 years, I think with 5-year increments of renewal. Just to flag a few concerns there, and for those who find this interesting, and Professor Anita Allen and I have an article that was just published on postmortem privacy, in which we discuss some of these issues and who should decide what happens to people after they're dead, including their digital replicas. If you don't want to become a digital replica after your death, can you stop that? Or can your family sell you off, particularly if you're a celebrity? There's a second issue of whether just ordinary people could potentially be animated after their death, even if they're not famous, they could be useful or in some niche way. Why should they lose their protection sooner than those who are commercializing their identities? And finally, we might worry even about celebrities given the tax system, because this will create an enormous amount of value in the digital replicas of famous dead people. And the IRS taxes property of an estate at its highest and best use, which is commercialized. So if a dead person doesn't want to be turned into a digital replica after their death and they have a sort of lucrative public personality, their heirs, even if they don't want to, may be forced to commercialize them to pay off a very hefty tax bill. I'm hopeful that that will also be fixed in the next iteration, but I don't know. Next concern is there is a strange preemption provision in the bill, which is somewhat hard to follow, but suggests that it preempts future digital replica laws either by statute or common law of any states. And that's ones that are passed after January 1st or maybe January 2nd, 2025. This is largely to leave in place the Elvis Act that was passed in Tennessee last year. California, Illinois, and New York, and I think 1 or 2 other states also passed digital replica laws, and they want to leave those in place, but not let any other states adopt any digital replica laws. This seems to me to raise some significant constitutional challenges for the enforcement of that provision, but it's also a little unclear because it includes common law. So if a state subsequently recognizes, say that its right of publicity laws at common law or privacy laws at common law apply to digital replicas, would that then be preempted because they decided it applied after the passage of the law? And there are a number of states, about 10, that haven't explicitly recognized the appropriation branch of privacy torts. So if they subsequently recommend that, decide that, would that be preempted? And then there's an interesting exception to this preemption provision for laws about digital replicas that apply to sexually explicit ones or ones about elections, which also I think raises some constitutional challenges. Final point, which I won't belabor, but which I may circle back to in a few minutes, is that this adds to what I've written about and dubbed the identity thicket. This particular digital replica law allows both individuals and rights holders to bring suits under here. Doesn't address what happens when someone owns or is an exclusive licensee of someone's digital replica, but somebody else, say maybe the individual or another company, if it's transferable, owns their publicity rights, the rights to their name, image, likeness, voice, and then who potentially owns the trademarks in this person's likeness or digital replica or voice or associated rights to endorse things. That may be a different person or different companies or in different categories. Could a licensee of a digital replica register somebody's trademark and then exclude that person from using their identity even after the expiration of the 10-year exclusive licensing deal? I don't know. And then there's this open question, which I will circle back to in a few minutes, about whether digital replicas are protectable under copyright law. And then if they are, who's going to own the copyright in that? All right. So a very, very complicated law. I'm told that people are so excited that it's bipartisan and that they might be able to pass something in the current Congress, that it may actually pass. Very famous people are coming out who are recording artists and actors who I don't think fully understand the 39 pages that they probably haven't read, and are coming out in favor of it. The record labels love it. Google and YouTube are not going to be liable, and the Motion Picture Association has its carve-outs for free speech. So I am a little concerned that it may pass in its current iteration, and if anybody wants to get involved in making sure it is improved before so, please let me know. Anyway, we could spend a long time talking about that, but I will shift gears to talking about trademark law in the scheme of, and now for something completely different that doesn't involve personality rights at all. People may recall that there was a Supreme Court decision involving a squeaky dog toy called Bad Spaniels, which was mocking both the name and the trade dress of Jack Daniel's famous whiskey bottles. In this case, this was a First Amendment case largely revolving around whether something called the Rogers Test, a sort of First Amendment doctrine applied only in trademark cases, would prevent the dog toy company from being liable because they were sort of making a comment about Jack Daniel's that was artistically relevant and not explicitly misleading as to sponsorship. The Supreme Court rejected that argument, saying this test didn't apply in the context of, first of all, what they deemed to be a commercial product, not an expressive work, and secondly, in the context where the use was as a mark. Some bad facts for VIP Products, the dog toy company, were that they actually called the product Bad Spaniels, they used it on a tag, and they tried to register it with the trademark office, so it was very difficult for them to argue that they weren't using it as a mark. Fast forward to a few months ago, the case was on remand, and the district court revisited some of its previous findings. It reversed itself on finding that the use was likely to infringe the Jack Daniel's mark, saying that it wasn't actually likely to cause confusion because of the parody, and because the Supreme Court in its First Amendment analysis said the likelihood of confusion analysis is itself infused with First Amendment considerations, the court said, given that and the fact of the parody, this would make it less likely that consumers would be confused because they would think Jack Daniel's wouldn't make this sort of derogatory parody of itself. Notably, on the bottle, it referred to the old number 2 rather than the old number 7 for the dog toy, referring to poop and dog defecation on your carpet on the label, which is not a great look, which gets us to the second holding by the district court, which is, even though it wasn't an infringing use of the mark, it was a tarnishing one and therefore dilutive of Jack Daniel's. And this makes sense. I said to the lawyer in the case that if this was not dilutive on the basis of tarnishment, nothing would be to refer to dog defecation in the context of a product that you would want to ingest. Left on the table was that the district court held that the First Amendment argument that trademark dilution law itself was unconstitutional had been waived by the dog toy company, given the litigation below. So there's still this open question of whether dilution law is constitutional or not. Some think it's not. Some think that it may be unconstitutional in certain contexts of application. I am doubtful that the Supreme Court will hold that dilution law is unconstitutional in its entirety, given some dicta in a variety of cases in which they look to and cite to trademark and dilution law as completely appropriate use of property rights and not at all running afoul of the First Amendment. But I do think that there may be some instances, particularly in tarnishment, if courts are taking sides on a particular viewpoint, which could be struck down on First Amendment grounds, but I think not in context like the Jack Daniel's case. This leaves me to copyright, and I'm almost done. And I wasn't planning to talk about copyright, but we lost a panel member, so I will pick up where Christopher also sort of picked up some of this weight. So there are a number of issues here. One that Christopher didn't raise was about authorship. And there was a recent decision just a few weeks ago from the DC Circuit in Thaler v. Perlmutter. Thaler has sort of a mission to try to register AI-generated works as copyrighted works, and he lists AI as the author. So I want to be very clear that there are debates about whether, right, about AI authorship and about AI-assisted authorship, and those are very different things. So Thaler really wanted to get a copyright registration and claim copyright on something that he said he had nothing to do with. It was the AI that created it. He could have made a different argument, and he tried to in litigation, that actually he like shaped the prompt and adjusted it in some ways, but he didn't in his registration application. The DC Circuit held that AI on its own cannot be an author for purposes of the Copyright Act, and the court the court was very clear that you need a human author. And I won't go into the details of it, but that was the holding. It's sort of uncontroversial. What's also uncontroversial is that for a long time, and continuing to be the position of the Copyright Office, authors who use AI to create works that they curate and control are copyrightable. There's currently a dispute. Currently, the Copyright Office requires you to disclose AI, and there is a bit of a debate about how much you have to disclose and what that is ongoing. And there's a recent report from the Copyright Office that addresses some of these issues. Just picking up a little bit on some of the other pieces here. Circling back to what can be copyrighted, there's this question of whether digital replicas are copyrightable. And for those who are interested in doing a deeper dive on that, I gave a lecture, the Donald C. Brace lecture in the fall, and the title was Copywriting People, and that's also available if you want to read it. And in it, I talk about, which is true, people are not copyrightable, right, in and of ourselves. But there's an open question. The Copyright Office has pending applications for people to register digital replicas of themselves or others. And it's not clear whether those are copyrightable, because generally when we capture a person in a photo or a film or a sound recording, that's copyrightable. And we tend to say, but the person within it isn't. But a digital replica, if fixed in code or in an output, is potentially copyrightable. And what does that mean for controlling the person depicted? Will other digital replicas be substantially similar to the ones that are registered, or stills from that? I think there are lots of open questions there. One related thing to what Christopher was talking about, there's ongoing debate on training data, but there's also debate about the outputs. And there are a couple of pending cases brought by Universal Music and a number of other record labels in which they've made copyright infringement claims on the basis of generative AI outputs. And they claim that they are substantially similar on the basis of sounding like the voices of the performing artists that were captured in the prior sound recordings. So that's really interesting, connecting back up to this point. You can't copyright people, but you can copyright the sound recordings in which they're captured. Universal Music and the other record labels are claiming that that could be a basis for substantial similarity finding and copyright infringement. And the last thing, and then I will stop, is just going back to something else that Christopher said, which is not about personality rights or IP, but is about First Amendment and the TikTok decision. I was in no way surprised by that decision, because national security is often a trump card for First Amendment defenses, and I suspect we will see that increasingly weaponized in speech limitations over the next few years. So much so that when I teach the First Amendment in the fall, I will probably add a day on national security and state secrets.
Excellent, all right. Well, so that's a lot. We have a few, certainly half an hour left. So let me ask a couple of questions for the group. Oh yes, let me say first of all that our next half hour has happened. So you, those of you who are getting CLE, need to write down or otherwise record this password, which is replica. All right, onward. So one of the things that we've talked about, we do this every year over the last few years, is that there has been sort of this trend recently towards the large tech companies being regulated, sued, sort of getting a lot more attention, right, from the regulators and from Washington. So where do you think that is going in this year? Because this is, not only current, but emerging, right? So where do you see that going this year? Obviously, we have these trials that are happening. We have remedy trials going on. Is that trend going to continue for the next few years, do you think?
My guess is yes. As you probably know, the tech companies were major presences at the inauguration, trying to make nice. Some people were commenting about that. My reaction is, this is what companies do. I mean, I found that unsurprising. You see mixed messages coming out of like the Federal Trade Commission. They want to be less regulatory, but they still want to limit the tech companies. And so how you do that is complicated. But most importantly, in the litigation that Gerald talked about, there was a chance to pull back on some of it. The administration does not.
Right.
And in fact,
Was that a surprise to either of you that the current administration did not change anything?
Trump was quite candid via tweet that he was going after big tech and going to protect little tech. That was his framing. And the current FTC chair, Ferguson, has provided the same sentiment, and the actions sort of back up the dialogue. There's a reason why we haven't seen any attempt to pull back the merger guidelines, in particular the application of vertical mergers. Additionally, as Professor Yu was saying, right, we had all of these founders, tech billionaires show up at the inauguration hoping to gain a little bit of political capital. If you need an example of why that doesn't work, just look at Facebook, right? So Zuckerberg attempted to settle the case that the trial started a few days ago, tried to settle that case over multiple months before the trial started. He felt that, so there's been a few news outlets that have reported this, he felt that by getting in Trump's good graces, that hopefully they could settle at a price that Facebook thought was reasonable. That number was like $450 million. The FTC countered and said, no, we want $18 billion. To which the final number that Facebook proposed was just north of $1 billion. It was presented before the administration. And at least what the news outlets have suggested is that President Trump gave an unequivocal no, go to trial and take him down. And so that's the sentiment.
One of my friends in DC said this current administration is all about leverage, and it's about transactional negotiations. And so even if there's an outcome, they won't back off the pressure early. They're just giving up leverage in that process. And I don't expect that to change.
I think there also may be some attention paid to, speaking of a different type of neutrality, of trying to get the platforms to not be engaged in sort of content curation. And we already see that not just in terms of algorithms, but in terms of coming in and addressing misinformation or what the platforms decide is misinformation in ways that I think the current administration think have been biased against them. And so I'm imagining that we'll see some more enforcement there to the extent that any of the platforms are still planning on doing that. A number of them have already backed way off their regulation of content on their platforms.
Good. So you see that sort of the trend is going to continue. But what about, so where, and Professor you talked about this some, I mean, Europe has been very active in trying to rein in the big tech platforms. And is this, and at least in the Biden administration, the administration sort of let it go, right? Just sort of said, okay, the big tech platforms have to deal with this themselves. Is that going to change, or do you think they're going to also continue to let Europe sort of be the leader in regulating large platforms?
The rhetoric has changed. The reality hasn't changed much yet. So what do I mean by that? Ursula von der Leyen is the president of the European Commission. She ran for re-election on a platform which basically promised to pivot away from heavy-handed regulation and more towards promoting productivity, innovation, and growth. and it's part of what I was talking about, a larger change. And then in September, Mario Draghi, who is the former head of the European Central Bank and former Prime Minister of Italy, dropped a very sort of significant report saying Europe is facing an existential crisis. That in fact, that Europe is investing less than half on a per capita basis what the US is in innovation, and that they're being left behind. And they cataloged a number of things. And the CEO of Ericsson characterized it nicely, said, we're risking of Europe's going to become a museum, and more than just in its old stuff. It's a place where you look for antique things that don't really matter anymore. And so they're worried about it. And you see this expressed in lots of different ways. I'll give you just a handful of concrete examples. Most US AI is not deployed in Europe yet. It can't comply. Copilot AI by Microsoft, Apple AI cannot find ways to navigate the privacy regulations or the AI regulations and some of the self-preferencing regulations. And they don't think they can. And in fact, what you see is that Europe had the belief that they're a big enough market and important enough financially that the US would never bypass them. And the answer is, if you can't comply, you can't comply. It's not a question, they would rather not. But if they looked at GDPR, they said, well, they complied everywhere and just did it. What they're doing with AI, there's just no way. Because they'd have to look at all the data they trained all their AI on, find out which ones had personal information, and give every data subject notice of their rights and honor the rights. They can't find them. And in fact, one of my students right now, her partner is in the business at the engineering school of scrubbing data, training data from identifying personal information. She says they can't do it because it's just too omnipresent in ways, and they can't find this. They don't think they can do it effectively. And so, and you know how this works even with AI, it'd be probabilistic. You know what I mean? So we'd have to do at best. And so what I find them finding is, I was talking with a privacy regulator in France, and they're trying to figure out a way out of they feel like they paint themselves in a corner and trying to find a way out because they think that they're having a problem. And that is a very different tone than what we saw until recently. Has it resulted in any concrete changes? The most charitable thing to say is not yet. Whether it will, no one knows.
So continuing a little bit on the AI point for a moment. So far, at least in the U.S. government context, we have not seen a lot of appetite for directly regulating anything about AI. But we are seeing regulations coming in when it sort of the No Fakes Act or other sort of digital replica aspects, or I think copyright law is likely to be a pretty important regulator of the way that AI operates and works in the long term. So what is your sense, and maybe I'll start with Professor Rothman, of, sort of looking big picture at, are we gonna get sort of a regulatory handle around AI anytime soon, or are we just gonna be doing sort of bits and pieces of little components of IP law or right of publicity law or privacy, child safety? I mean, is it gonna be that, or do you think we'll ever see, a bigger, more comprehensive regulatory?
I think it's going to be piecemeal and ad hoc. I testified over the summer at the House Task Force on Artificial Intelligence, and they released a report, I think, at the end of the year, the beginning of this year. It was sort of a grab bag. But in terms of what's actually been introduced or proposed in Congress, I have not seen any comprehensive bills regulating AI. I think this actually poses some significant problems for First Amendment analysis of these laws, which is of these bills, which I have said, that if we have one that's targeted about sexually explicit uses, and one that's targeted about political misinformation, and one that's targeted on protecting sound recordings or the entertainment industry, even if it's written more broadly. But all of those are regulating unauthorized uses of a person's identity. Then each one of them is potentially at risk for First Amendment challenges of being under-inclusive or having other problems in terms of being under-inclusive, but also potentially discriminating against different types of uses in ways that I think put them on thin ice. So I think that the No Fakes Act may survive such a challenge because it potentially picks some of those up and is styled as this intellectual property right. But I think not thinking, and I said this to the task force, but not thinking more comprehensively, I think puts at particular risk efforts to regulate AI and political misinformation. And I think those will be struck down, and I think if they had thought about deception and tried to include it in something like no fakes, it would withstand First Amendment scrutiny. So I think it's a big missed opportunity to be thinking more comprehensively, but like many things, I'm not sure my suggestion will be taken.
And if you look at the first Trump administration, the executive order on AI was not regulatory. It was about enhancing competitiveness, promoting U.S. industry. And in fact, the Biden executive order was quite different, and it's been revoked, and the new declarations are very, very different. The other thing is, what you're getting at is, are we going to regulate AI across the board with one big, what we call horizontal regulation that spans large language models, autonomous vehicles, healthcare, use in employment, criminal law? And that is what the EU AI Act kind of aspires to be with different categories. There is a growing question about whether that's the right approach. In fact, so we're doing an AI standards project, and one of the standards we're looking at autonomous vehicles, it's not a single safety standard. It is 26 separate scenario standards. And I can think like medical AI, are we gonna have a single medical AI? We're gonna probably have one for, MRIs and EKGs and then therapeutics. And I mean, there's probably a core of stuff that's common, but the actual implementation is gonna be very, very different. And the lead agencies today have been the National Highway Traffic Safety Administration and the Food and Drug Administration. And they're by far the head. And it's an interesting structural question. How many AI agencies do we want to have? And the answer is we may end up with a lot of them, is the way we're currently going. And that might be the right answer, depending on how we think the structure of the law should be.
Yeah, so I just want to chime in there because I was talking about a comprehensive thing to address unauthorized uses of people's identity. I think uses of AI across different industries are dramatically different and need to be treated differently. And I do think in talking to legislators that they are the greater fear in the US versus what I hear in Europe is that we will stifle innovation and therefore fall behind. So with the exception of, I think, and this is why the No Fakes Act, I think, is moving more quickly than some of the other AI-related bills, is that it has, significant, right, it's record labels, right? It's significant parties with lots of lobbyists and lots of money at stake who are trying to protect their piece of the pie in this changing landscape. And so they're able to get something through. But otherwise, I think the valence is very much, we're afraid to do anything that would stifle technological development and AI development because we don't want the US to fall behind.
And then, I think that speaking of areas where there's been an enormous amount of technological development and potentially the regulations racing to catch up, we would be remiss in having a space law expert on the panel without asking, every time I look up, there's another satellite. What is going on with regulation of space?
Remarkably little.
So it's just the Wild West still?
It truly is, actually. I think there's a few contexts that fit the analogy better. The sentiment coming out of the United States is that traditional multilateralism no longer works. And so that's why we have the Artemis Accords, for example. We are going to go down the route of customary international law for the foreseeable future, and I don't think that is going to change. And so what it ends up being is courting as many countries as you can to follow the principles and ideas that you want to put forward, and the U.S. is taking the charge in doing so. That's led to a lot of semi-questionable, at least proposals. They're not behaviors yet. The most notable of which is appropriating or exploiting resources on the moon, for example. The Artemis Accords is very explicit in suggesting that, and there's also a law that was passed in 2015 2018, I believe, so space providers wanted some legislation to come through Congress that essentially said, in the event we get up on the moon, we want to be able to take resources and make use of them. Please provide us authorization to do so. That's what this law does. It's also what the Artemis Accord suggests. And so the idea is the SpaceX's of the world go up, they land a lunar rover on the moon, they want to appropriate resources, most notably, some hydrogen is notably known on the dark side of the moon, and they appropriate that resource. This law says yes, as do the Artemis Accords. The Outer Space Treaty is a little more questionable. In particular, it declares that you cannot establish any sort of sovereignty on the moon. The argument that is being made is, well, we're not establishing sovereignty because once it's movable, right?
We're just taking it.
We're in the world of chattels, and it doesn't matter, and we can take it and use it at will. And now there's mincing between, okay, well, if you appropriate the resources to use them as fuel for future missions going to Mars or wherever it may be, is that okay? Versus I appropriate the resources, think minerals, right? Not only on the moon, but also in asteroids, and bring them back down to Earth in order to sell them, right? Is that above board? The United States' position is yes, you can do that, that's perfectly fine. Plenty of countries are going to dispute that and already have. There is a committee called COPUOS, it's under the UN, that deals with, under the UN, not the United Nations. It deals with all sorts of space activities. None of this is legally binding, right? They're just proceedings with recommendations. The last 5 years has been the United States fighting with China and with Russia about every issue, but this issue shows up every single year. I would say the other thing that is quite notable in the Wild West nature, we're dealing with this concern that the amount of debris that is being left in space is going to cause severe harm, right? There's this thought of what's known as Kessler syndrome, where we have a chain reaction where the debris is just, it proliferates to such a degree that portions of space are no longer usable. And in particular, what's known as low Earth orbit, right? Anywhere between 400 to 2,000 kilometers. That is where everyone wants to be right now. The ISS is there, the future space station is going to be there, the Chinese space station's there, and every satellite operator that has any chance of making a profit is there. There are certain countries, including the United States, that have taken a very concerted approach to ensuring that we don't create additional debris. In fact, we want to hopefully mitigate it. The Chinese have not taken that approach, largely because they believe they're severely behind the United States, and in particular SpaceX. So what is concerning right now, they are deploying their own constellation. It's known as Thousand Sails. It looks eerily similar to the Starlink constellation. It also started to look eerily similar right after SpaceX was hacked and all of their design prototypes suddenly went out in the ether. Maybe pure coincidence, where I'm going to try to draw connections. Nevertheless, what is concerning from an orbital debris standpoint, the Chinese are currently leaving every one of their second stage boosters, so the launch vehicle that includes all of the satellites then spit out, they're leaving those boosters at 600 kilometers, every single one. There's about 65 of them sitting there right now. There will probably be, if they do actually deploy the constellation they envision, several thousand. That is particularly scary. They're very big. We've already had 2 of them explode and cause massive debris events. And so on one side, we have the United States doing something that might be moderately irresponsible that other countries are pushing back on. On the other, we have a separate country doing something definitely irresponsible that the United States is very concerned about and pushing back on. Again, there are no hard and fast rules here. It's all norms-based. We hope that people find consensus, but right now there is very little of it.
Excellent, thank you. All right, we have a few minutes left, and so we will take some questions from the group. If there's any questions on any of the topics. Yeah, Ashwita.
This is a question for Professor Rothman. So now if you look on Facebook or Instagram, a lot of posts are sort of tagged with this made with AI, I guess like tagline it looks like. To me, it seems like they're over tagging everything, but I was curious to know from your perspective with the proposed legislation, where that kind of fits in. And then second, do you think that's adequately protective?
So the proposed No Fakes Act as a provision that disclaimers are irrelevant. So even if you disclose that it was generated by AI, that doesn't relieve someone of liability for creating or disseminating or making available a digital replica of someone. So from that perspective, it wouldn't matter. There are other laws where if you're deceiving consumers and consumer protection laws that might apply, though are not specific to the sort of digital replica or AI context, but if you're deceiving people that something's authentic or that there's an endorsement when there isn't, regardless of whether it's using AI or not, you could be liable. So their notion is you could reveal that it was generated by AI or unauthorized and escape liability. No Fake says that won't work, and even in false advertising law and trademark law, disclaimers sometimes help, but sometimes they don't. So if they feel like someone's really profiting from the value of someone else's identity or mark, even if you disclose that it's unauthorized, or even if in this instance you disclose that it's AI, you might not escape liability even without the passage of this legislation. With that said, I do think that there should be increased focus on deception. For example, in revisions to the No Fakes Act, I think it should really matter whether the public is deceived as to whether a person participated in a performance, so that even if someone does sign their rights away or there's a license, but they're not really supervising it either because they don't care or they just lost control of it, I still think the public should be aware of whether it's an authentic performance by this human being or not. And so I would like to see some affirmative obligation. Obviously, the recording industry and the motion picture industry don't want to have to reveal whether something's authentic or not, because that may undermine the selling power of the digital replica, or in some instances, it might be intrusive to the work itself.
Great. Other?
Yes, I do have a question. You mentioned that there is a regulation on the recommendation system, and also you mentioned about that there has been parents suing TikTok because they were harmful for children. So I was wondering, like, to what extent would the responsibility actually fall into the platform versus the users, considering, like, for example, TikTok has been implementing a few tools and measures to cope with harmful content. There has been, you can report illegal content, inappropriate content, you can block, they even filter content, they moderate content. So to what extent would the responsibility still fall within, like, platforms?
Yeah, so to be clear, the law that I mentioned is currently enjoined on First Amendment grounds. It's actually round 2 of it being enjoined. So the Utah legislature passed the law. It was very expeditiously struck down. They said, oh, well, we're going to amend it. They amended it by adding like 3 clauses that basically say nothing, and then they went back before the court and was struck down again. So it's currently enjoined, so no parent is actually suing under that law specifically. The reason why it is concerning, right, if it were to eventually, they were to allow that provision to be enacted, is that it's essentially saying if a minor has any sort of mental health harm or event and believes that there's a causal connection with using a platform service, whether it's TikTok or something else, that law would suggest that there's a presumption of causality, that for sure the platform used it. So how does the platform then rebut it? You can't produce evidence based on a child's mental state and a doctor's note. Like, there's really not much they can do. And so that law specifically has one carve out. And the carve out says, well, the one way you can avoid liability is you just don't curate content. It's just a chronological feed. What we've seen, because there's been numerous studies done by these platforms, when you do that, engagement goes away, so it kills their entire business model. Additionally, there have been some studies that suggest that if individuals want to find harmful content, so think, now we're getting into polarization or misinformation, right? They're just as likely to find it when it's a reverse chronological feed as if it were a targeted feed or a curated feed, for example. And so under that law, to be seen, I don't think it will ever see the light of day. We do have multiple states attorneys general right now suing both Meta and TikTok on the grounds that their algorithms are harmful and spur public health concerns and various.
Some of these are like products liability theories, right? Yeah.
Several products liability. One is under a public nuisance theory, which is very interesting. So there's a multi-district litigation case in the Northern District of California at the moment. I believe it was 19 states. As far as I'm aware, check, because I haven't looked at it recently, it has made it through the motion to dismiss phase, so 15 of the 19 states still have a claim on public nuisance grounds. Now, why is that particularly odd? Well, it's not specifically tied to land, which is often what's required under public nuisance. It's not clear what the public harm may be, so it's on behalf of multiple school districts that are asserting that claim. And it's not necessarily clear what kind of the specialized degree of harm or damage is relative to the public writ large. And so, again, we're at the very early stages of litigation. They're going to have plenty of time to prove this, but the fact that it's at least made it through the motion to dismiss phase is quite interesting.
And to emphasize the importance of the distinction that the lack of causation, why that's important. So one of my things I was active in, there's a National Academy of Sciences, Engineering, and Medicine did a report on the impact of social media on the mental health and well-being of adolescents and teens. And we had to do it through peer review. And the question was, does the data show it's harmful? And we see a lot of correlational studies correlating mental health harm with social media use. But the causal studies are very weak to non-existent. And a number of the causal studies show the arrow goes the other way. It's not that social media use causes depression, it's that kids who are depressed use more social media. And it's in which case, cutting them off from social media the way Utah would do would be a very detrimental outcome. And there was a pretty clear tone that it depends on the population. Like there's certain isolated rural gay youth depend on social media. And you find it more complex. Within a month before we issued our report, the Surgeon General issued a report saying the exact opposite. Now the interesting question, his question was not, is there proof that social media use is harmful to the mental health of youth? It's a question, is it proven to be safe? And I would say the inconclusive evidence, it was equally not provable that it was safe for them to use. And the question is, in this world where you have ambiguous evidence, what's the inference? Taking away proof of causality makes you have to prove something that's almost impossible to prove. And so it's going to have, that move will have a tremendous impact in terms of what the outcomes on liability will be.
And I would just to piggyback slightly, the other thing that's quite interesting, if you remember, there was the Facebook leak and the whistleblower, right? And they released a bunch of emails and slide decks and whatnot. People have parsed through those. There is one slide deck in particular that's going directly at this issue, and they say, look, we've done a myriad of studies. It seems that 25% of, in this case it was girls, age, I want to say 10 to 16, something like that, or 12 to 16, say they feel worse about themselves after they use Facebook or Instagram for an hour or more. 25% also said they felt better about themselves after using it. So this goes directly to the point, right? There's very ambiguous evidence. We're not sure what that relationship looks like. And so the other thing that's very concerning here is we're trying to regulate something we're not certain we understand completely. Are we kind of just taking shots in the dark?
All right, and the shots in the dark is a good way to end.
We need your final password.
Oh yes, all right, so we are finishing up, and the final password, for those of you getting CLE, is platform. Platform. All right, so thank you very much for coming. This has been, I think, a really interesting and informative discussion. We will see you next fall. We always do in the fall a preview of the Supreme Court term, so we'll do that sometime in the October-ish timeframe, so look for that. And then we will be back here probably in April again, doing a review and prediction of what's going on, and probably talking about even more of these issues. So thanks very much.
Great.
Thanks to my
Good job.